Yes, Mr. Gidney. Perhaps to forestall what I imagine you're about to tell us, we've been sent by the diligence of both teams quite a lot of material over lunch. We've been sent by you the bundle below. Thank you. Haven't looked at it, but it's only background. And we have been sent by Ms. Dan Reuter a bundle of other ET decisions, I think 4 in all, with a helpful email quoting what they said. I've read the email, but not the underlying documents.
I haven't had a chance to review those cases.
No, well, look, I think it is very unlikely that they will have any kind of significant outcome on the result, but it's still useful for us to have them because we get a feel of the kinds of situations which can arise, and that, speaking for myself, that's all I intend to use them for. If in the very unlikely event that we regard some point that emerges from them as very important and nobody's had a chance to address it on it, we'll ask for further submissions, but I think that's extremely unlikely.
My own friend and I were going to just raise that possibility.
Yes.
As we go forward on that in terms of those.
Well, I'm not a great fan of further submissions. There's no reason why all points that are raised at the hearing can be dealt with at the hearing. It's an opportunity for second thoughts. But if completely new points emerge, which there's a good reason why they weren't taken, then we will consider an application to make further submissions. But I don't think unless we ask for them, I don't think we're likely to be sympathetic to an application to make further submissions about Ms. Dan Reuter's 4 more cases or the 2 we knew about already.
Indeed. No, I can't imagine.
Of the 2 we knew about already, which I have now looked at, in a very crude way, looking at one went one way, one went the other. Shows that facts are, I don't know whether you've had a chance to look at them, but shows that cases are often quite sensitive to their facts. Yeah.
Right. What I should just say in response to that, I understand that Ms. Dan Reuter has sent the original trial bundle and the witness statements and her submissions.
Oh, right. Sorry, I thought that came from you. I was paying you.
From me, hopefully, you should have my submissions pack, which contains.
Oh, I see. Yes.
Plus,
sorry.
Right. Plus the submissions, though. So I think that's it's that plus the cases that's been the new material sent over lunch.
Mr. Reuter, is it me or Mr. Gidney who's mispronouncing your name?
Your Honour, it's Mr. Gidney.
I apologise. It's probably much better that way. Right, I thought I would just pick up on a couple of points that were covered this morning, very specific points.
Yes.
The first was in the right at the beginning, where we discussed the whether or not the circumstances of danger is a separate part of the test in section 100(1)(d) of the Act. That came about before His Honour Judge Tayler in the EAT, when we were considering a decision actually that was before him, but not before this court, in which Her Honour Judge Stacey referred to Underhill, which talks about a 2-stage test, and then said, in fact, it's probably 3. The first thing you'll do is establish whether there are circumstances of danger, then move on to consider whether there was a reason.
Yes, I saw that.
Etc. As well as you already observed, that wasn't a matter on which His Honour Judge Tayler felt he had to come to a sort of final position on. At that hearing, it's right to say that I was in Her Honour Judge Stacey's camp. In other words, I said you would, if you look at section 100(1)(d), it does appear to have clear stages to it. The first of which would be
okay, well, you can take it shortly, I think. You were originally in the same camp as her. Are you about to tell me you're not?
Well, I think I accept the force in the example that His Honour Judge Tayler gave in terms of a gas which is believed to be serious, but then turns out not to be. I think it would be avoiding the point slightly if a respondent could defend that claim simply by going into the issue of whether or not, as a matter of fact, the gas was dangerous. The fact is that people believed it was reasonably, and then left and then were dismissed.
No. Well, speaking for myself, I see the force of that as well. We'll have to decide whether it's a point we ought to address, given it doesn't actually matter for the purpose of the debate. But if we do, I now know where you both stand on it.
Yes, and maybe it comes down to the reasonable belief, because if
it certainly has to be a reasonable belief, yes.
So if an employee took a position that was demonstrably absurd, then that would, even if that was genuinely held, I don't think it would
no, quite.
gain the protection of the Act.
Thank you.
The second was just picking up on the paragraph 33 of the Tribunal's judgment, which is at page 88.
Yes.
That is the judge, although she's citing that in the context of there being inconsistencies in the claimant's evidence, it's her recording that he is accepting that the workplace, if the guidance was being followed, probably was safer than the world at large. And I think is a finding of fact that was said by the claimant and accepted by the...
it's not a finding of fact, it's a recitation of the evidence.
Recitation of the evidence.
Yeah. Yes.
Paragraph 33. I find the claimant's case confusing. His views apparently contradictory. He gave evidence all the measures described by the respondent were in place, and that would make the business as safe as possible from infection. He gave evidence that this would possibly make the workplace safer than the community at large. And I think that does go to the...
Well, no doubt this was a reflection of your cross-examinations.
Indeed.
Yeah.
But I think that does go to the question of the judge's conclusion that there wasn't a reasonable belief in circumstances of serious and imminent danger, which is clearly what she records in paragraph 66 of her judgment, which is in the bundle at page 93. So the only other point that I just wanted to pick out from this morning, what I said that both the employment judge and His Honour Judge Tayler made an observation that there was no other particular danger identified on the commute to work that would,
yes.
Would require some further analysis. Having had a good look at the ET judgment, I don't actually find that the Judge Anderson specifically made that point.
No, well, that's why I was a bit surprised. I don't think she did, but
it was one. I don't think it was one that she directly addressed on. But it was picked up by Judge Tayler at page 75. That's at paragraph 48 in his judgment.
let's have a look at that.
So paragraph 48 which is headed analysis. So Judge Tayler said, even if the Employment Tribunal had erred...
Well, shall we quickly read the whole paragraph to ourselves? Yes, I see. It's the last sentence.
It's the last sentence. So it didn't assert any particular difficulty. I think an important part of this appeal is the question of whether or not the danger can be completely separated from the workplace, or whether it needs to be connected to it, related to it, or actually in existence within the workplace. Certainly, if ground one is to proceed, then we would be looking at a scenario where a danger over which the respondent has absolutely no control, which doesn't affect it at all, the danger is not in its workplace,
Well, the danger is in the workplace, isn't it? Because there are employees in the workplace, any one of whom might have COVID and be infectious.
Yes. So what you're looking at then is whether or not the claimant's belief of a serious and imminent danger. Now, this has been put in terms of a nuclear explosion that doesn't affect the workplace but does affect the route to it as a means of allowing a claim to be made in those circumstances. When you look at the authorities which do talk about the danger potentially being outside, the first is obviously Harvest Press, which we've looked at this morning. And quite rightly there, the employee is within the workplace. If you're looking at steps could be averted, you might ask, well, could either of the employees be moved to another site? If that's been asked and said no, then an employee in those circumstances will have to leave. In the second decision that we looked at in this context with the parachute and the bus tyre concerns, which is the
On roads.
yes, both of those concerns originated within the workplace. So there was a dangerous parachute being built within the workplace, even if the danger itself wasn't going to manifest itself until somebody much later, nothing to do with the workplace, used it to jump from a plane, or indeed a danger to the risk of an accident on a bus. Still, there's a connection to the workplace. So I think, insofar as it's being suggested that there doesn't have to be a connection to the workplace, then I would invite you to reject that submission. I think, and I can refer at this point to the averting the danger aspect of the test, because if a danger outside the workplace, not affecting the workplace, could be sufficient to bring this claim, then it will render the statutory protection, the statutory safeguard of averting the risk completely odious. So there couldn't really be any way of averting the risk in those circumstances. So what we are focused on here is a case in which an individual reasonably believes that there's a risk within the workplace and feels that he has to leave as a result. Classic example being a machine that is unguarded and his employer just refuses to guard it. He's tried to take steps to avert that by asking if he refused, he leaves.
It's not a very good example, is it? Because a machine that's unguarded doesn't harm anybody unless you're actually having to work on it.
If his role is to work on a machine for which the guard is broken,
even then, surely all you could do is say, I'm not going to work on it. I'll do something else. Doesn't
but
it
it
go
could
home?
be.
But a better example, I shouldn't say my own examples are better, but a better example are the ones I gave earlier, the roof that evidently is about to fall in, or the furnace that evidently is about to explode.
Well, in those, say that if you have a danger that is a risk to the entire workplace, it may be impossible to avert, so you'd leave in those circumstances. There may well be circumstances under section 101D where an employee seeks to avert a particular risk to him, and if he can't do that, then leaves. Then he would have protection. In all of these cases, the existence of the danger is within the workplace, and is tied to the workplace, and that must be right. That it's as I say, I'd invite you to dismiss any suggestion that a risk that has nothing to do with the workplace can give somebody a claim.
But it does have something to do with the workplace in the sense that there's a risk of catching COVID from your fellow employees.
Yes, no, I think I would accept that. In this, if you're looking at this generally speaking, you would say, well, is there COVID in the workplace? What can be done about it? And if you're looking at an employee then thinking whether to leave or not, then he would consider what steps he may take to avert that risk, such as insisting on coming in at staggered times or not mixing with other people or social.
That wouldn't avert it. That might mitigate it.
It may well. It could avert it. It could just be a question of mitigating it. But when we're coming down to that question of someone's reasonable believing that there's a serious and imminent danger, at the time we know, and I think this does tie into the guidance, when you have somebody that or employees being told that social distancing, hand washing, etc., sanitising are steps that will protect you, then those are steps that can be implemented. Now, if we turn then to the judge's findings, this was in support of the proposition that either the claimant didn't actually believe there to be a serious and imminent risk, or that risk was unreasonable. She set out what steps had been put in place to make the business safe and to create a scenario in which there wasn't a serious or imminent risk of a serious and imminent danger. And I've just identified from pages 86 and 87 in the judgment, you'll see at paragraph 18, there's a risk assessment that was done identifying social distancing and staggered start times. At 19, social distancing. We do know that this was a very large workplace. The tribunal was told about the size of half a football pitch with 5 laser cutting machines in it and no more than 5 employees. So actually social distancing was not a problem in this workplace. And then at paragraph 20, page 87, hand washing, social distancing, and at 21, the wearing of masks. Now, there was a discussion earlier about what exactly, at paragraph 15 of the judgment, was being referred to in terms of 48, and I'm afraid I tried to sort of have a fairly narrow construction on paragraph 48 of the tribunal's judgment. But I think on a fair reading, you'd need to take into account the entire paragraph as to what the judge was referring to when she says at paragraph 50 that I do not consider any belief that there were circumstances of serious and imminent danger were objectively reasonable, largely for the reasons set out above. Because in paragraph 48, she sets out the factors that meant that this wasn't a reasonably objectively reasonable belief, namely the steps that had been taken, which we know claimant accepted probably made the workplace actually safer than it was outside the workplace. So in their conclusions, both the Employment Tribunal and the EAT, and we accepted and this is at paragraph 64, page 93 in the Employment Tribunal, paragraph 44, page 73 in the EAT, that the coronavirus could in principle amount to a serious and imminent danger outside, but on the facts of this case, that was not the case. So this wasn't a scenario, I think, in which the possibility of COVID creating a risk was being ruled out. And I think it was suggested that may have been the way in which this appeal was being put. It's possible that it could do, but just not so here. I think it's also right, the Employment Appeals Tribunal analysis on the serious averting the risk. The tribunal found, binding on us, accepted as being binding on us now, that there were steps that could be taken, except that there is potentially a blurring as to whether or not the steps could be taken undermine the objective and reasonable belief in the serious and imminent danger, or if there was a danger, that the claimant could have averted the risk by taking those steps. Indeed, if there was evidence relating to a particular concern in coming into work, one would have thought leaving the house, driving in, going straight to the machine for which is social distancing would be steps that would avert the risk. So this is that's a separate factor which I think is difficult given the findings for this appeal to get past for the reasons that I have set out. I know that my friend sought to put a passage from Hansard into the authorities.
Well, he hasn't
issue as to whether or not that would be binding on you at all, or whether you'd be assisted by looking at it.
Well, if you want to refer us to it, you'll have to persuade us that it's admissible, and if you do, we'll look at it, and we might have to look at it depending essay. But at the moment, nobody's referred to it. So, up to you.
I think all I would say about it is that
Well, I don't even know what it says.
well, it's not a matter that I was seeking to rely on. I certainly wouldn't.
We don't normally look at parliamentary debates. There are strict rules about when we do, and sometimes it's useful. But
I think in the circumstances, there's nothing really
you're not saying about it. Okay.
Need to say about that. So ultimately, then, did the tribunal conclude that because the claimant didn't have a belief of a serious and imminent danger in the workplace, but did at large, that was an error of law? And I don't actually think that was a finding that the tribunal made. I think as the Employment Appeals Tribunal did, if you look at the reading of the judgment as a whole, then it's quite clear that that was not the conclusion. The conclusion was that on the circumstances of this case, the claimant hadn't made out that there was a reasonable belief in a serious and imminent danger in the workplace that caused him to leave, or which caused him to stay away. He simply left business. I think, well, unless there's anything else, there's not on that specific point that we've been dealing with. There's not a lot more that I can.
No, thank you, Mr. Gidney. Any reply, Mr. Transend?
I'll try to keep it relatively short, my lord.
Very short. It's not.
So, if I can, I'll try. This may not strictly be a reply, and I apologise, and I take any objection.
Let's see what the point is.
So, the starting point in the statute, as a matter of statutory construction of section 101D, is that there is no reference on the face of the statute to circumstances of danger being confined to the workplace. That must be the starting point. And the draftsman could have comfortably written into the statute in section...
It doesn't sound like a reply point to me.
My lord, it's not... so it's not, with your consent, I would ask...
it doesn't even sound like a new... I'd be... Speaking personally, I can't speak for my lord, my lady, I'd be quite indulgent about a new point that occurred to you over lunch, which you hadn't made before, which Mr. Gidney then had the chance to reply to. But if so far it sounds not only not a reply point, but just a restatement of the points in your chosen argument.
So, my lord, what I was going to do, if I can, is probably a response to some of the questions which have been asked. Hopefully not repetitious. There's a couple of new points, but I was going to, in order to get there, I was just going to make a couple of points, probably sequentially, which I may have made already. But I've got less than half a page of notes.
Let's see how it goes.
Right. So the starting point is that the draftsman could have simply written into subsection D, in circumstances of danger at work, which the employee reasonably believed, etc. It could have done that, and that would have made clear that circumstances of danger were confined to the workplace. Here, the statute has been drafted widely. You've got my submission. It's drafted widely enough to include circumstances of danger outside of work. Your response when you highlighted something which the Employment Tribunal judge had noted, which was you said, well, look, why should liability be visited on an employer who's taken reasonable steps to reduce or minimise the risk? And I have two answers to that. These are these are the new points. The first is that the employer doesn't have to dismiss the employee. So the employee says, I can't come into work because of circumstances of danger outside of work, nothing to do with the employer. And the employer can say, okay, well, you can't come in, I understand that. They don't have to dismiss them. And you had asked the question about the contractual position. There is then no contractual right to pay. The employee is not ready and willing to attend work and therefore has no contractual right to pay. And so what happens is you have the employee remaining at work, off work with no pay. The employer, yes, has a slightly disadvantageous position. They've got an employee who can't come into work, but there is no real treachery or difficulty that the employer is putting other than the fact the employee can't come to work. They don't have to dismiss. And so, so that's the new point. And then again, a development of that is that if they did dismiss, the damages are going to be quite limited in any event because you have the employee who's off at the time who couldn't come in. And so this seems on the face of it like a potentially onerous position for the employer to be in, but they don't have to dismiss, and even if they do, damage is not going to be particularly large. The secondary point, again, relates to this, and why your question, why should liability be visited upon the employer in this situation when you're weighing up both interests of the employer and employee? My answer to that is actually that this is a different type of automatic unfair dismissal to a whistleblowing dismissal or a pregnancy-related dismissal, and I'll try and explain why. In those circumstances, there's a wrong. The employer has dismissed because an employee's blown the whistle, Section 103A, or because an employee is pregnant. This is a different circumstance where imagine an employer has done everything in their power to try and make the workplace safe, but for no fault of their own, they couldn't do so, and an employee has a reasonable and genuine belief that the workplace presented a serious and imminent danger, and they were dismissed for not attending work. In those circumstances, liability would fall at the employer's feet, despite the fact that they've done everything conceivably possible to try and make the workplace safe. And so what you can see is there could be circumstances where liability is visited upon the employer where they've done nothing wrong.
Yeah, okay, I've got the point.
And so this is a different type of automatic unfair dismissal. It's not one where there's some nastiness necessarily imputed on the employer. That's the second point. I think those are all my submissions.
Yeah, thank you.
Yeah, so it's simply on bottoming out the compensatory point, which is because there's no basic award, I said the losses were limited, they're limited because the employee would have been off work and not earning in any event. And this isn't a case where they would have been get the bonus, if you want to call it that, the windfall of a basic award because they haven't had 2 years service.
Okay.
So my Lord, those are my submission. I'm grateful for your indulgence.
No, Mr. Gidney, do you want to reply on those points as far as they were new?
I think it's just to make the point that this is an automatically unfair dismissal regime. So in the circumstances in which my learned friends described them, a dismissal may well be unfair and somebody with service could still bring that claim. But I think in order to fix an automatic liability on a respondent in these circumstances, then there does need to be something within the workplace that's caused the danger for which there is a danger and for which it is objectively reasonable for the claimant to take that view, which on the facts of this case hasn't been established. I think that's all I'll say in reply.
Thank you very much, Mr. Gidney.
Is there anything that you would like us to address you on either disposal or the cost application, or is that something that
No,
would be best left?
well, costs certainly we deal with insofar as they're contentious once you've got the result. In fact, in this case, it's all predetermined by the cross-counting order, isn't it?
Yes,
So
I think both, someone from the confirmed, I think both.
disposal, I think my lord and my lady have flirted with the idea that if this is a very unsatisfactorily reasoned decision, we might have to remit rather than make a final decision. No, neither of you have been asking us to do that. I think I haven't discussed this with my lord and my lady. They can kick me under the table if their loans are not enough. But if we were thinking of going down that route, we would invite brief oral submissions, or not brief written submissions, rather, on that. I think that's really disposal is either we uphold the decision of the ATE or we don't. But I agree, if we don't, we wouldn't have to allow the claim. We could send it back. Okay.
Well, only one brief matter on the issue of costs. I would ask that if we were to lose and you were minded to make an cost award against us, although the costs are capped at £2,500, I would ask that we're given the opportunity to make brief submissions.
Well, I said, I'm sure you're aware of this, Mr. Claimant, but when you get the judgment in draft, one of the reasons is to agree a consequential order, or if you can't, to make brief written submissions on the dispute, which is, in this case, you're hypothesising about costs. So that's the time to do it, when you see exactly what we've decided and why. Thank you both very much. We will be reserving, as I've largely anticipated, you will get the judgments in draft, so that you can draw our attention to any minor typographical or factual errors, but principally so that you can agree the terms of a order, or if you can't, give us brief written submissions so that we can resolve them before making the order. The judgments will be sent only to those addressees whose email addresses you supplied a day or two. That doesn't mean a day or two ago. That doesn't mean they may not be circulated further, but only for the limited purposes set out in the Counsel General for Wales case, to which, as you know, the court is attaching considerable importance. Very well. Thank you both very much. All three very much, I should say.